Ready, Mark? All right. Good afternoon, everyone. Thank you very much for coming. I'm Cheryl Wood, the General Counsel for the Palm Beach County School Board. Today I am going to introduce Chris Anderson, who is going to be speaking with us on ethics for advisory board committee members, which all of you are. Chris received his JD from the Florida State University College of Law after majoring in history at Huntington College in Montgomery, Alabama. Chris is a member of the Florida Bar, the Jefferson County Bar Association, the Florida Government Bar Association, and the State General Counsel's Association. He serves as General Counsel and Deputy Executive Director of the Florida Commission on Ethics, recently having been promoted from Chief Assistant General Counsel. Previously, he served as an Assistant State Attorney in the Second Circuit, as an Assistant Public Defender in the Seventh and Second Circuit, as a Senior Attorney for the Department of Insurance, as an Assistant General Counsel for the Department of Corrections, and as a private practitioner. Also, Chris is a past recipient of the Florida Association of County Attorneys Ethics Award and its Appreciation Award, and is a frequent speaker on statutory ethics and related topics at bar CLE programs and other events. At the end of your program today, I would like you all to please complete your acknowledgement form, and that will indicate that you have taken this class and you're good to go for your advisory committee work. And the others will need to do it by video because this is a mandatory training course, and I appreciate all of your attendance today. Thanks.
Thank you, Cheryl. Now, Mark, I'm going to cut this off. Is that correct? Cut it on? Okay. Thanks. I was talking to Mark over there. He's been most helpful, the technical man here, and he also put me on to some good food in the cafeteria. Now, y'all are probably spoiled because y'all probably eat there all the time, and you think, oh, this is just old hat. But I'm telling you, I thought it was pretty good. Of course, I guess, you know, getting off of an airplane and coming through airports, you think everything's good, but I think genuinely that was good. So if anybody's listening, the cafeteria people are here are good, and I enjoyed it. And also, that thing you need to sign, I think you need to sign that in blood. Is that right, Cheryl, that they attended today, since it's Halloween and since it's also a serious matter? And I think I'm being recorded. Hopefully I'm on film, too, as well as audio, because I'm wanting to send this to Hollywood, you know, because if they put my shop out of business in Tallahassee with state cutbacks or something, I need an alternative career. So I'm kind of, you know, getting a screen test out of this, so y'all be kind to me now. You know, we need the proper applause at the proper time and that sort of thing, and then maybe I can make these producers interested. But, no, in all seriousness, I appreciate being able to be here today, and I appreciate the invitation from Elizabeth McBride and Cheryl's office, and I appreciate all of you being here. And I appreciate everything you do in your capacity as advisory committee members. And all of you that may watch this later, whatever sort of committees you are on, I appreciate your service, because I was noticing just in some of the documents on the school district's website, you know, the reason for advisory committees is to have full involvement of communities and the community as a whole in all points of view. And something that's very important, which is public education, especially in the district that's the size of yours. Now, the part of Florida I come from, we've got some vibrant public schools, but we don't have anything that rivals the volume that you have here and the many things that you need to be involved with. And I think when you have that much on your plate, you need to have more committees. You need to have more subject matters, if you will, that people put a particular interest in all the time. And, you know, some districts probably just have maybe a group of advisors because they're not very big. But when you have what you have, you need to break it down like you have. And I noticed the different types of committees you have. And don't let the word advisory fool you from either an ethics standpoint, which I'll get into more in a minute, or from the standpoint of your perceived significance or insignificance to the district, because you have that label advisory. I mean, advisor is what it's all about. I mean, you know, Aaron was an advisor to Moses in the Old Testament, and that was a pretty important function. And advice is the cool-headedness that people have when they reflect on something, and they're able to bring that position to bear then on the people that work day to day. And it makes a big difference, I think, for you to be there. And And because your functions are important, you'll find out in more detail as I speak further why there are certain standards of conduct that the state law imposes upon you in your service. Can everybody hear me pretty good with the setup and everything here? Is it playing right? Thank you. I wanted just to take a couple of minutes to explain about the Commission on Ethics that I work for. And some of you probably know something about it. Maybe some of you know nothing about it. But essentially, the Florida Commission on Ethics is a creature of the state constitution and a creature of state statutes as passed by the legislature. Now, what happened originally was back like in the 60s and before, there had been a desire in Florida to have a commission on ethics and have a code of ethics that governed the conduct of public officers and public employees. But of course, you know, the legislature, with the many things that they had on their plate to deal with, as well as the fact that people are reluctant to pass laws that they may themselves be subject to, you had just decades and decades where you had no action. There was nothing in the Constitution or statutes really creating an ethics commission or ethics laws. So Governor Askew took it upon himself to promote a citizens' initiative amendment to the Florida Constitution, which was successful and resulted in what is now codified as Article 2, Section 8 of the Florida Constitution. And that provides for the Ethics Commission and provides for certain particular standards of conduct that go to persons that file full financial disclosure. And it provides for the ability for statutes to be enacted to have other ethics standards. And so the Commission on Ethics resulted from that, and it's a 9-member board. 5 members are appointed by the governor, 2 are appointed by the President of the Senate, and 2 by the Speaker of the House. And it's designed to be politically balanced, so you have no more than a certain number of appointees from each person that makes appointments can come from a particular political party. So you have the situation where, say, if you have a Republican, which is the case now, that's the governor or speaker or Senate president, all Republican, they're all fishing around to find a couple of acceptable Democrats to put in, you know, on their appointments, and vice versa. When you had Democratic people in there, you had that sort of thing. And so one of the advantages of working for the Ethics Commission is you get to learn who is a person in one party that is reasonable enough that they can associate with members of the other party, such that they could, you know, get appointed. But anyway, it's a 9-member commission. They don't get paid like you don't get paid, but they do get expenses when they travel and that sort of thing to Tallahassee or wherever else they might need to go. And they meet about every 6 weeks, and we do a whole lot of work in between gearing up to preparing an agenda for them with lots of items on it that includes complaints, advisory opinions, financial disclosure issues, rules, proposed legislation, that sort of thing. And we have lawyers on our staff, we have investigators, we have financial disclosure people, we have support personnel. Probably altogether we have about 25 employees, so we're not a big agency. And our investigators do cover the whole state, so they travel out of Tallahassee when they have complaints that they need to investigate. Now, in terms of how the commission operates, it operates basically on 2 tracks. One is advice or advisory opinions, and the other is complaints. Now, my friend Bruce Harris there is an expert at getting advice up front for people, as is Liz McBride and all the attorneys of your office, including Cheryl, the head, about getting advice ahead of time. And they'll contact us and say, look, you know, we got this situation. We need to figure out if somebody's going to have a conflict, if they take a certain outside job, or would they be like misusing their position if they did something, and does so-and-so have to file financial disclosure. So a big part of our function is talking with attorneys for government agencies, as well as individual members of boards can call us, but frankly, it's best to filter it through the attorneys at the given agency because you probably get more of a focused inquiry and maybe a quicker response. But we like to be involved on the front end there where people get advice so they don't get in trouble versus being involved in our other process, which is complaints, where people do potentially slip up and somebody files an ethics complaint against them. Then the person is sort of in a defensive posture, and it's not as pleasant as if they're asking for advice ahead of time. So the big message there is, when in doubt, inquire, either directly or through attorneys at the given agency or through a private attorney if you have one, or you might at least want to check our website and look at some of the subject matters that are there and educate yourself. And let me take a minute now to make a plug for that. And, you know, it's easy to find our website. You just Google it or whatever, but the exact address is www.ethics.state.fl.us. And what we have on our website is we have the statutes that are part of the Ethics Code. We have a guide to the Ethics Code, which you can find right there. It's called the Guide to the Sunshine Amendment, as opposed to the Sunshine Law, which is the Open Meetings Law. The constitutional provision I mentioned is shorthand called the Sunshine Amendment. But you can look at the guide, you can look at the statutes, you can look at our rules, which are quite in-depth on issues such as gifts and that sort of thing. And you can also look at past advisory opinions that we have issued that may very well be analogous to a question you might have about yourself or an attorney might have about somebody in the district that they're looking at an issue for. And the website's pretty self-explanatory, and it has a query box where you can do some searches and that sort of thing, and so it's useful. And I would urge you, if you haven't looked at it, to go there, especially reviewing that thing called Guide to the Sunshine Amendment and the Code of Ethics. Now, you might say to yourself, okay, I'm not paid, I'm on an advisory board, what's the big deal about me and the ethics law? I'm not making any money out of it, I'm not a paid person, I'm just a volunteer. And the answer to that, like I've sort of alluded to already, is you may be a volunteer and you may be unpaid, but what you do is very, very important and often makes its way into policy that will be implemented and will be something that will affect thousands of children and lots of workers and other things that the district is involved in. And our people on our commission are very important with what they do, but they don't make a dime out of it. They're not paid either. And I myself, years ago, I was on a local planning commission for a county, and I was not paid there, but I was involved in a lot of decisions where somebody could or couldn't upzone or downzone their property, and it could cost them, hundreds of thousands of dollars. And so, advisory doesn't mean insignificant. So therefore, the ethics law does capture advisory board members, and it does so because advisory board members are within the definition of public officer. And that's a definition that's found in Florida Statute 112.313, subsection 1. And basically it defines public officer to mean any person elected or appointed to hold office in any government agency, including any person serving on an advisory body. So it couldn't be any plainer. And similarly, when you get to the voting conflict law part of the ethics code, you have the same definition of public officer in 112.3143, parentheses 1, parentheses A, Florida statutes, which is the same definition, including any person serving on an advisory body. And then you say, well, okay, I'm a public officer. What does that mean? Well, it doesn't necessarily mean that a person that is a public officer has to file financial disclosure. People that file financial disclosure are public officers, and they are certain public employees, but they're a subset of the overall definition of public officer. And many years ago, before another part of the Ethics Code, which is Part 3, Chapter 112, Florida Statutes, many years ago, before the code was amended, there was always a difficult question to answer as to whether a person was a member of an advisory body for purposes of financial disclosure. Because in the past, to file financial disclosure at the local level, all one had to be was a person that was on any sort of board, any sort of collegial entity, as opposed to an employee or somebody that just had a unitary position. So if you were on any kind of board in the past, you had to file financial disclosure unless you were on an advisory body. And there was a particular, yet again, definition for that you had to do the analysis. Well, that, for financial disclosure, has all gone away now. And it's been simplified to identify who at the local level files financial disclosure. There is a finite listing in the statute in 112.3145 as to the types of persons that are required to file financial disclosure at the local level. And it is no longer everybody on any sort of board. It's only people on certain boards. And the analysis about whether a board was advisory or not for financial disclosure is now a thing of the past. Now, where the significance of advisory board officer or advisory board member remains important, one of the areas is the ability to have a waiver from certain types of conflicting employments or contractual relationships. And some of the statutes in the Ethics Code do not allow a person to sell or rent goods, realty, or services to their own political subdivision or their own agency. Now, for purposes of that statute, the school district is a political subdivision. A city is a political subdivision. A county is. So, just as an aside, if your public position is with the school district, typically there wouldn't be any problem with you or your spouse or your child or your company or your employer doing business, say, with the county or with a city or with another school district in another county, unless there was some cooperation or some actual interface where you'd have a conflict. These laws are mostly geared to somebody doing vending or some sort of interface with their own entity. Here, yours being the school district and not others like the county or a particular city or another school district. But anyway, let's just say, for instance, that one of you had a company, or your spouse or your child had a company, or you worked for an entity, even if it wasn't yours and you didn't own it. And that business then proposes to do business with the school district here, where you are an advisory member on one of the boards, one of the committees. Well, there might be a need, after you go through another analysis, to have a waiver of a conflict that could be there. And that waiver is available for members of advisory boards only, not boards that have final decision-making power. And assuming that you did have a business-type conflict between your employer or your company or your spouse or child's company, there was some sort of business conflict with the school district, and the district decided, well, you know, we know there's a conflict there, and we know that this board member, advisory board member, is affiliated with the vendor or the company, but nevertheless, we think that we want them on the board, so we're willing to waive that conflict in this instance. Well, the board has to do that by vote, and it has to be done on Commission on Ethics Form 4A, which you can find on our website. There's a thing on the left that says Forms, and you click on Forms, go to 4A, and it explains it all in there about how it is to be done. Now, a school board member who's not an advisory board member, they can't do that kind of waiver. They have to just abide by the law straight up. But when you're advisory, there's the ability for that value judgment to be made. You know, we know there's a business thing here technically, but we're going to waive it because we want to keep the person on the board. Now, often you don't have to go that far, though, because, as I'll explain in a minute, you may not have a conflict to start with that necessitates the waiver. You might not meet the elements of the prohibition to start with, to put it in lawyer lingo. So what I wanted to do is I was going to go through some of the substantive parts of the Ethics Code that apply to advisory board members and touch on them. I already touched initially on what makes you governed by the Ethics Code, the jurisdictional hook of these definitions that define public officer to include members of advisory boards. Then I mentioned the doing business with one's agency prohibition. And these things are all summarized in that guide on the website. But You know, the idea about doing business with your own agency is that if a person is a decision maker or has input on the public agency side of a transaction or a proposed transaction, and then on the private side of that transaction, their employer, their company, their spouse's company, their child's company is the one that's offering the product to the district, then, you know, you're going to have that problem of not being able to be objective. It's like, you know, similar to nepotism, which I don't want to go too far on that because, you know, our nepotism really doesn't affect school districts, but I think you do have a local policy that you're implementing. But, you know, when it's your own relative that's being hired, that's a similar dynamic to your own company is being contracted with, or your spouse or your child's company, or your employer is up for selection among others. Your objectivity is just completely destroyed in that situation. So, for instance, go back to the top for a minute. A school board member, if they're voting on entering into some contract for certain services, first of all, they shouldn't be voting on it because of the voting conflict law if it's going to affect a company they're connected to. But secondly, even if they abstain from voting and the board entered into the agreement, if you didn't have some sort of exemption out there, they'd have what I call a status offense, one of these business relationship problems. And the same thing could be the case for an advisory board member. The difference being, though, that when you're on an advisory board, let's say that the board you're on is over in a particular subject matter of district operations. And that's really the only place that that advisory board is functioning. That's what it's doing. It's in that subject matter. And I think all of you can probably think about the different kind of boards and how there is that separation of subject matters. It's not like you have one advisory board for the district that advises the district on everything. It's broken down into different parts, different areas, different subject matters. So let's just say that, and I don't want to make this too simple. I don't want to insult your intelligence. But let's just say that you had an advisory committee. I'm just making this hypothetical that dealt with playground equipment for elementary schools. That's an advisory committee on that. And then there's another advisory committee totally separate that deals with fire suppression equipment for high schools. And never the two shall meet in terms of their subject matter and what they deal with. Well, it might be possible that even without a waiver, there wouldn't be a conflict for a given advisory board member to be connected to the company that dealt with the part of the district that was the different part of the district than what their advisory board was concerned with. And the reason for that is there's no loss of objectivity in that scenario because there's no role whatsoever of that advisory board person or their board or what they do for the district related to the separate subject matter that's completely distinct. And so in that situation, you probably wouldn't even need a waiver. But say that you were in the same subject matter as your board and your private company or your spouse or child's company or your employer is in that same subject matter, like you're on the high school fire suppression equipment advisory committee and your spouse's company sells fire extinguishers. And you know, part of the advisory committee's job is to recommend things about fire extinguishers. Then, you know, you're going to have a problem if your spouse or child or their company or your employer deals with the district on that, absent either waiver on using this Form 4A or absent applicability of one of the other exemptions in there, such as true seal competitive bidding or sole source of supply or something like that that's listed in the guide. And so you have to go through sort of a rigorous analysis to see whether or not you need to have a waiver. But if it turns out you do need a waiver, then because you're on an advisory board, you're able to get one if the board sees fit, whereas the board members themselves or certain other officials don't even have the possibility of getting that sort of waiver. And also, if you had that kind of waiver, it would only be good for that particular instance of doing business and not necessarily for the next contract that comes up or something different or some regulatory conflict that exists outside of the business conflict. Any questions on any of that? And if you have questions at any time, I'll be happy to take them. Just raise your hand. You don't have to wait till the very end because, you know, when you do that, you run out of time and then you don't get to ask. So if you have a question, you know, raise your hand. But are there any questions on any of that to start with? okay? And like I say, these business statutes are front and center a lot of times, with ethics issues. Then moving from that thing where you had that possibility of waiver, we moved to another, and those, by the way, those two statutes I just mentioned, or if you want to write it down, but the guide will tell you 112.313 subsection 3 and 112.313 subsection 7 with the waiver and the other exemptions in 112.313 subsection 12. But moving away from that sort of status offense, which doesn't require any evil intent, it's just an incompatibility of the private hat and the public hat in relation to the same subject matter. We move to another statute, which is probably the most interesting of any of our statutes. It's called misuse of public position, and that's 112.313 subsection 6. And what makes it interesting is that it requires corruption or evil conduct. You've got to know something is wrong, and you've got to involve your public position or other elements of your public position or resources within your trust. You have to bring your public position into some conduct that you know is wrong, and nevertheless, you go ahead and engage in that conduct. And the reason that you do it is to gain or attempt to gain some sort of private benefit for yourself or somebody connected to you in a private capacity. And it's a real generally worded statute, and it's been upheld by the courts as being not void for vagueness. Some of you probably know a lot of times courts will strike statutes. They'll say, look, I read that statute and I don't know what conduct it prohibits, therefore it's void for vagueness, it's unconstitutional. Well, this statute has survived that constitutional scrutiny, and it's pretty simply worded. It just says no public officer, which of course would include you, or public employee or local government attorney shall use or attempt to use their public position or any property or resource within their public trust in order to secure a special privilege, benefit, or exemption for themselves or another person. And that kind of language is good to be general because it encompasses all the realities of life. Everything from leaning on subordinates for sexual favors to stealing money that one has access to in their public position to manipulating certain situations to achieve some sort of private monetary type outcome for somebody in an improper manner. And we've had some real interesting cases on that. Now, also very interestingly, in regard to the interesting statute, is that we really don't issue advisory opinions on this statute. And that's because it's sort of hard to give a view as to one's mental state or what lawyers call mens rea, to get this wrongful intent element. You only know that when you see it after you've done an investigation under a complaint and you get facts on the ground. You can determine if somebody acted with a requisite wrongful intent. So it's hard to do that if somebody asks a question like, if I do this, will I have corruptly misused my public position? It's almost impossible to give an opinion on that legally. And then practically speaking, like say the case of leaning on subordinates for sexual favors, you're not going to get a supervisor asking the Ethics Commission in an open forum a question of, well, if I'm in the elevator by myself with my secretary and she's refused my advances, can I try to give her a kiss in the elevator? People just aren't going to say things like that. They're not going to put that out there practically to be opined on. So these things are really sort of wait for investigation, as opposed to those status offenses that I mentioned earlier, where you need to come up front and say, look, if I engage in this business relationship, is that a problem, or not? We encourage that, but these misuse things really aren't going to be something that can generate an opinion ahead of time. They have to wait for the reality of the complaint and the investigation. Now, most of the complaints that we have filed with us deal with misuse of public position. Yes. Yes, sir.
I have a question. I'm
Yes, sir.
Calvin Crockett. I hold a seat on the court committee for the school district. I actually am an advocate for about 37 small and minority businesses here in the Palm Beach County. And my representation for Cork is the MWBE. Now, I'm basically the voice that makes sure that the policies and procedures from the public, state, and federal standpoint are being held accountable. So when I'm advocating for the members of the organization and holding this seat, is that a conflict?
The gentleman's question is if he's advocating for members of a certain organization, is that a conflict? And tell me again what the organization is, if you
It's
would.
the National Association of Minority Contractors. We're the South Florida chapter.
Probably want to tell them what CORC is, too.
CORC is the Construction Oversight and Review Committee for the school district.
Yes, sir. And that's the committee you're on. That's your position here.
That's correct.
And on the private side, do you hold any employment or any office in any organization, or are you just a volunteer advocate?
I am the founder and ED of the South Florida chapter. So, yes.
Right. Now, that particular organization, though, it doesn't sell anything to the school district, does it? It's not
No.
a vendor.
No.
And so the interface it has with the district is an advocacy interface only, is that correct?
Well, I think this young lady just solidified, most of our members are construction. They're in construction, and they're looking to bid and secure opportunities to build or renovate on the schools.
Okay, and that's the members of the umbrella organization.
That's correct.
Right. And but when they do business, when the members of the umbrella organization do business with the district, that contract would be between their particular construction company and the district. There wouldn't be any contract between the umbrella organization.
That
and the
is
district.
correct.
Yeah, I think that umbrella rule you have there would appear to me not to trigger any of these status offenses about having a position with a company that's vending or doing business with the district. If you had a position with a particular construction company also, and it did vending to the district, then you'd have to go through this analysis that I mentioned. But just the advocacy itself is not prohibited by the Ethics Code. There's no desire in the Code of Ethics to stymie debate or advocacy or argument on issues. I mean, we want robust public debate. The idea behind the Ethics Code is the only pinch, if you will, that the Ethics Code puts on debate would be an end to really none. It's what the Ethics Code desires to do is to free up debate to be pure debate by taking monetary concerns out of the discussion and also taking gift concerns out of it, which I'll mention in a minute. But just advocacy for entities and that sort of thing usually is not addressed by the code, and it's certainly not a misuse of public position, for one, in their private capacity to engage in the provision of information to their public agency. You can always think of a certain scenario, what if this, what if that, but normally speaking, when you come from the outside in the private capacity, even if you hold a public position, usually just a mere advocacy is not a problem without more. And that kind of helps me segue into what I was going to mention about this misuse statute, is that any time you have a choice being made by an advisory body as to what they're going to advise to, or by the board as to what it's actually going to implement, there's always, these policy choices always result in winners and losers. And without fail, we get quite a few complaints where people that are on the losing end of a valid policy decision will file an ethics complaint against those that made the policy decision, saying that they're unethical, or that they misused their public position, or they were immoral, or they're going to hell or something because of what they did. I mean, you get that all the time. But, that's not what the law is talking about. The law is talking about somebody doing something that's clearly inconsistent with the proper performance of their public duty, and they know it is, and they do it anyway for a special benefit to themselves or somebody else. And that element of the conduct having to be inconsistent with the proper performance of public duty is not there when it's a policy choice, because it's not inconsistent to choose between valid alternatives. You have to make that decision. That's the substance of government. And so we get a lot of questions on that, but when you're doing that, it's typically not a problem. Yes, ma'am.
I'm very happy to hear that he has no conflict, because he's a great asset to our committee. But to just use his setup as an example, and I don't mean it this way, but the difference between this waiver and this conflict of interest, if we were to vote on the selection of a contractor and one of them were one of his groups, is that where he signs the conflict of interest form, or is there no conflict of interest either in a selection process?
I'm glad you asked that question. And you were saying, well, what about when you vote on things or when contracts are awarded? Well, there you need much closer scrutiny as to who you're connected to with particular business entities. Like being connected to a particular contracting firm, when it's getting a contract, you'd have to go through a detailed scrutiny on all these statutes to make sure you didn't have a problem. And when voting on it, you'd have to back off of the vote, declare the relationship, abstain from the vote, and file the voting conflict form. Now, filing that form and abstaining from the vote and declaring the abstention won't cure it if it is, in fact, a status offense under these earlier statutes I mentioned. But there's no waiver possible for the need to have a voting conflict and the need to abstain, and there's no waiver possible for this misuse of public position statute, the corrupt thing. There is a possible waiver, if you need it, for these business conflicts under 112.313.3 and 112.313.7. But I'm glad you mentioned voting because advisory committees are collegial bodies, they operate by vote, unlike, say, a superintendent who's just one person or the head of a department. So, and then the voting conflict law, as I mentioned definitionally, also specifically applies to including persons serving on an advisory body. And just because the advisory body can't make the final decision doesn't mean that their votes are not an important part of the process that leads up to some turnkey application that does put money in the pocket of somebody or does affect somebody privately. So you need to scrutinize any sort of vote you're on. Now, tell me if I'm wrong about this, but I don't think any of the advisory committees, by their vote, can actually award a contract, can they, to somebody? But you might be advising as to what kind of contract you want, or triaging out applicants possibly by recommendation. Is that possible? Yeah, and so you need to look to see who's in the pool of affected persons, who's going to be sent forward, who's going to be eliminated, who's going to be recommended for an award, to see if it's a voting conflict or not, if it's a direct and insular enough effect on the voting member and their company or their spouse or their business partner's company. Anytime that there's a vote of your board, of your body, if there's a vote of your committee, and potentially affected by that vote is your company or your relative or somebody else connected to you, and there's a list of all those people in the statutes, then you need to go deeper before that vote happens and see if you have a problem. And sometimes it might be necessary to put a vote off if you can, so you can get better advice, so that you don't stumble. But what I always tell people is if you're not sure about the effect of a vote and you don't have time to get better advice or methodical advice and you don't have time to put it off or you can't put it off, then what you need to do is just take the safe position and consider it to be a voting conflict. And say, look, I'm not going to vote or participate in this because Company X, I own stock in it. Or whatever the reason might be. Then be an abstention and then file the Form 8B, which is another one of our forms, within 15 days of that. But you need to also remember it's not just voting. I keep emphasizing it's also analyzing these potential status offenses of whether or not the contract is entered into or not, regardless of whether you abstain from voting. Yes, ma'am.
Just to get back to this example, he's not making any money if one of the people in the organization gets the contract.
That's correct.
He's not making any money.
So
that's no conflict then, is it?
Typically not, because the idea behind the law is the particular company that's going to get the contract. You've got to have some sort of connection with them, not just with another entity that's just a mere umbrella of the particular company that's benefiting.
I just wanted to clarify that I just wanted to get the difference between conflict of interest and the waiver and use this as an example, but I know...
It's perfect for us.
Okay.
It works for me as well.
Right.
And typically you only need the waiver if you actually have a conflict to start with, and the conflict to start with usually doesn't exist unless it's your company or your spouse or your child's company or your employer that's going to be in privity with the school district through a contract. and it's not these advocacy umbrella sorts of things. I guess if somebody were paid as a mercenary for an umbrella organization to lobby the same issue as their advisory committee is interested in, that could be a conflict, and that the employment as a lobbyist of your own agency could be a problem. But I don't hear you saying that you're employed to do that. Is that right?
I am the ED, and part of my position is to be an advocate.
Okay, so you are paid as executive director, and you're supposed to advocate toward your advisory board?
That is correct.
Uh-huh.
That's for all policies and procedures to meet the requirement of small minority business.
Have you ever done one of these waivers before or not?
No.
Uh-huh. That might be something you might want to explore on that. I mean, I'm not saying you definitely need to do it, but you might want to explore a little further on that, on that situation. Now, let me ask you, for your particular committee that you're on, is there any enumerated qualification for you to be a member, or does it say that one member of your committee, which you hold that slot, shall be an employee of an umbrella organization advocating this? Is there something like that or not?
No, but there is the MWBE policy of the district, and there is the position on Cork that is supposed to represent the MWBE. So it has that policy plus that position to be held.
Right, and it may be that he's okay there under yet another part of the ethics code that says when there's a statutorily or by ordinance or similar criteria, a purposefully infected criteria for membership, if you will, with something that would otherwise be conflicting, then sometimes it's not a conflict. But those things have to be worked through on an individual basis. And if in doubt, I think people ought to get waivers if in doubt. But, you know, that's probably more of a detailed fact pattern than we can get into today. But it's good, I think, that everybody's on inquiry notice about that possibility. Liz, I hope I hadn't bogged down in one or two things too much, but how are we doing time-wise? I think you said total of 45 minutes. Another 10 minutes? Thank you. And let's see. There's also a provision in the Ethics Code that deals with disclosure or use of what's commonly called inside information. That is, if in your public capacity you become aware of information that is not available to the general public and you gained it through your public capacity and you use or disclose that information for your benefit or the benefit of any person or business entity, then that can be a problem also. And that kind of is self-explanatory. It sort of goes without saying. I mean, there's not much of that sort of information around anymore with the Sunshine Law and the Public Records Law. But it can be violated if somebody gets information that's technically or ultimately public, but they have it a little bit ahead of time, and it's only through their personal capacity that they have it. Then they run out and use it for the benefit or gain of themselves or their company or some other person or business entity. Then that statute could be violated in those situations. And that's sort of an intuitive statute, kind of like the misuse statute. You kind of know when you ought not be doing that. Now, there also is another statute in the Ethics Code that deals with solicitation of gifts or things of value. Basically, it's bribery. You're not supposed, and this goes for advisory board members, all these things I'm mentioning do, as well as other types of officers and employees. You can't accept or ask for something based on an understanding that your vote or your other official conduct is going to be influenced. Obviously, that's a no-brainer there also. Then there's yet another statute that talks about people receiving something of value when they know or they should know that it's given to influence their official decision-making. Now, the should know part is what's interesting, because if it's no, it's kind of like the statute I just mentioned. You kind of know they're giving it to you. It's almost like you've accepted it. You shouldn't do it. Well, what if you haven't asked for it and it just comes out of the blue? Somebody that's interested in the workings of your committee gives you a free trip or offers you a free trip to Hawaii or whatever. Then, of course, you shouldn't take it. Because even though there's been no quid pro quo or no actual understanding of a bribery there, you ought to ask yourself one rhetorical question. Why is this person or this company offering this to me at this time? And if the answer is, we're going to be making a bunch of decisions here coming up to recommend certain policies that might affect their company, and they're trying to dump this gift on you, then, of course, you've got to back off from that. Now, the fact that, do any of you file financial disclosure? Not lawyers, y'all don't have to answer, but any of you committee members, any of y'all ever filed? Probably you don't have to when I was looking at the situation as to how you're set up. Plus, the state law, which again doesn't mean you're not subject to these things I'm talking about, but the fact that you don't file financial disclosure means you're not subject to this more detailed gift law that's in addition to the two things I just mentioned, where people have to worry about taking gifts from lobbyists worth over $100 and that sort of thing. Now, you may have a local policy that's capturing this with vendors and others, but in terms of the state law, if you don't file financial disclosure, you're not subject to that micromanaged gift law with the $100 limits and the reporting and all that. But you are subject to those two I just mentioned about not taking things when you know or should know you shouldn't take them. So you're lucky you don't have to go through that detailed gift law. It's quite a morass. Anyway, then there's a new statute that deals with charter school board members and personnel, which is makes them subject to some parts of the ethics code. And I don't think in your capacities here, are any of you affiliated with charter schools? Is there a charter school advisory committee, or is there no such animal? Okay. So that's sort of a sideline thing that's out there, but not really within the district like you are. Any questions on anything so far? And I'm just going down a list here of some things, and we kind of got to voting a little bit ahead of time, but what the voting conflict law goes to is like votes, collegial action. And you have to be careful when you're doing that you realize that the collective action of the board, even by, everybody's in consensus, that's like a unanimous vote. You don't have to go down the line and say, how do you vote to have a vote? You got to be real careful about that. You all probably understand that because I think I saw some stuff in your local stuff on the website that talks about votes and that sort of thing and how they're to be counted. So when you have collegial action, basically that's a vote. You want to make sure that you abstain and declare and file and don't participate without doing so. And of course, you always have to abstain from vote. When I say participate, I mean discuss. You've got to declare, you've got to abstain from voting, and you've got to file the voting conflict form on any vote or measure of your board that would directly cause special private gain or loss to you, your family members, your employers, or certain others. The Ethics Code also recognizes the ability of local governments to adopt more stringent standards than the things I've been talking about that are in the Ethics Code. Now, when a local government adopts additional standards, they can be more strict, but the local government, here the school district, does not have the ability to pass anything that would undo the state law. The state law is always there. You always have to follow it. What the local stuff does is maybe makes it more strict for you, and that would be prosecutable or enforceable at the local level as to whatever that additional prohibitions go to. In terms of our processes, again, like I said, we have complaints, we have ethics opinions, and we want you to call us for advice. And we got our number on our website, and it's best if you filter it through a lawyer, but you don't have to do that. You can call on your own. We're there for you, and we encourage you to get up with us. And we appreciate what you do. And I think if I have a couple more minutes, are there any questions here at the end? Yes, Bruce.
I just want to point out, and Mr. Anderson was involved with this, there have been occasions in the past where advisory committee members want to know, do they have a conflict, do they not? We've asked Mr. Anderson, who can issue informal opinions, and he's provided them. I can think of a couple of instances where the committee had nothing to do with what the business was that the person was in with the district. So based on that, different type of subject matter provision, if you recall, your letters indicated there was no conflict, there was no need to go through the waiver issue. And in terms of voting conflicts, last year this district asked for an advisory opinion from the commission. So we got a formal opinion relating to school advisory councils and the type of voting conflicts they could have. Mr. Anderson was involved with helping to draft that, and some of the provisions they dealt with were, well, teachers have to be on these advisory committees by state statute, so some of the types of decisions they make aren't going to be conflicts. So that's a good opinion to read, in terms of voting conflicts, because it goes through a lot of the law on that issue.
Thank you, Bruce. I appreciate you mentioning that. If I had just like 1 or 2 more minutes, like the level of advice you need from, a lot of times you can go to the lawyers at the agency and you get your good answer there and it's solid and there's no doubt about it and you don't need to go to us at all. Now, sometimes we need to be telephoned. Sometimes we need to get a letter. Rarely does a question need to go on the Ethics Commission's agenda itself. And the reason I say that is they don't meet that frequently, so it takes a while to get that action. And we've issued so many opinions by the Commission itself through the years that we have a large body of precedent out there that can govern new similar inquiries. So if that's the case, a lot of times the staff will just write a letter. And we call that, like a staff letter response. And if we tell you there's good in that, then you can rely on that. And you don't necessarily need to get on the agenda. What typically goes on the agenda is novel questions, interpretations of new statutes, or things that are just such hot potatoes that they won't go away, that they have to have that treatment. But the ethics code. I mean, you heard my biography there, and I've got a lot of lawyer jobs in the past I've been involved in, criminal law included and stuff. And I've never seen the level of complexity till I got to the Ethics Commission on particular statutes that I've had to deal with here. And so the way we handle that is we have that strict letter of the law, but then we do have 9 human beings that are a member of the commission, and they're not 9 computers. And so we try to make this law workable for people, and that's why we're in business. And there's, some of that is out there. And again, we're there for you, and I appreciate your service, and I appreciate your time today, and it's been a real pleasure. Thank you.